starts
Right,
with it.
it still has things starting. Most of the time. Or half the time more, half the time more.
I need 100% out of this. Arnold should never let me down.
I'm turning it off.
Yep.
Stuff. And then I will check. And then this is actually turned off. I'll just put it up like that.
I'm still gonna be able to hold the digits.
Yeah.
Different one.
If you call those numbers, call them in the next couple of months. I told them. I just don't need it. I want to know that we're preparing. Hello, Mr. Katz. Hi, this is Lillian Woods. We are in the process of setting up the equipment, so we're going to need another couple of minutes, but I just wanted you to stand by and we'll have this set up for you. Okay, thank you, sir. I'll call you back. He's standing by.
It's taking longer than usual.
Court of Appeals without the bench, and I'm asking if parties have reviewed the draft decision.
Yeah. All right. You already did that. Did you
I'm
do
a
that?
Division II guy, yeah.
This will be my first time in Division One too.
What do you think of the draft decision?
Do you have discussions about doing that or no?
Not that I'm privy to.
Well, they've been doing it for about 20 years, and nobody else does it.
Yeah.
Yeah.
Now that
But they
is-
swear by it.
They
They
swear
do,
by it.
they do.
As practitioners, as in a peering form, Division Two, do you appreciate having the draft decisions up front?
I used to appreciate it, and now I'm the lone wolf in the wilderness who doesn't.
Really?
Everybody else appreciates it, but I don't anymore.
I appreciate it because, I think two reasons, because it is nice to have, and I think there's a reason against it. I think it's giving you a false sense of where things are headed, because a lot of times the person that writes the draft is actually like the one dissenter who's kind of on the fence or something, so you'll get one and then the decision ends up being the opposite.
That hasn't happened in 7 years now.
Well, that's
The last
me.
time that happened,
Maybe I was just one.
was the Johnson case that became Arizona v.
We
Johnson.
gotta hit that. I mean,
At least in criminal, in civil, I don't know.
No,
In criminal,
I had it happen in Illinois.
yeah.
And then I think the other thing I like about it is if they're going in a direction that
Oh,
goes
it's
to
not.
read off.
Yeah, but I come prepared.
But it's true, I know, I'm just saying that, once in a while, courts come out
all
with
right,
things,
Lord,
oh, I didn't think that's where you were going.
Come on now.
But, I don't know, I think most of the time, it's kind of neither here nor there. I like it, but I think it's,
A little extra, but you're kind of arguing,
yeah, I
for
mean.
the most part, the same way you're going to argue anyway.
But I'm the only person who does not like it,
Why do you like it?
because of I haven't seen the draft become
She called
consensus
us.
in entire time in my whole
It didn't
And
run
then
in
I'm
some
saying,
cases.
how does
Draft.
they hear him? Will they be able to hear clearly?
Well, actually, I I don't even know, I'd have to look back, it either came to the dissent or that person flipped.
That's gonna be a rude awakening though, after.
Mm-hmm.
Make it work. That's all I can say. You can leave this on.
It's funny, I didn't know
Let's
that.
get it set up.
Because
By
when
1 o'clock.
I was on it, they always warned you about that, oh, be careful.
Why don't you hurry up and leave it doing this thing and try to make it work the other way?
But I never see it. Doesn't really change the way you are, it's just not what you're at.
Make it long.
My ex-husband was very It'll work. In the end, it'll work.
He's on standby. We just want to come in.
Everyone wants to talk to themselves, the kids want themselves, and then after that, the pre-conference, the post-conference, pre-conference. It will work out.
I was watching Undercover Boss, and I love that show.
I've seen that before.
Oh, God, they got a cinnamon bun lady on there, and one guy came in. Sounded like Undercover Boss to me, and she's trying to stay cool with that part of it. He didn't. The girl didn't really catch him. That's funny. But she would have been easily caught anyway, because first of all, she's looking at cinnamon bun, young people, mostly mole, and then even with a wig on, it's a little too stylish and classy. You know what I mean?
Yeah.
You
No,
know
it
that
just
one.
doesn't
She got
quite
money,
sound-
even with a
quite
wig
sound.
on, her lipstick and makeup was impeccable. And I said, they have been well, this woman is not working at that level.
So, she's waiting on the. Try that show.
Oh, I love it. I absolutely love the show.
Yeah, the shtick is mostly finding interrupt people feeling appreciated.
Yeah. And a lot of
Does
them
that go the
line
other way? The
Yes,
undercover boss?
wonderful. And direct TV. A woman was sitting on the client, you know, on her nerves, she hung up on. So she got training, but I knew that she would not stay with the company. I wouldn't say anything anyway, but I said, I wouldn't say anything anyway.
Yeah. Already signed.
You know what, procedurally, do I need to ask the court when I first get up to reserve?
You'll keep your own time, but as Judge Morris will mention, it's not like the court know, they will try not to inundate you with questions.
Keep it
for the-
That's okay, that's fine.
So whatever you end up with, you do want to.
Okay.
Okay, so you wanna call on the regular line? We might have to just do it on here. On the phone. How does she contact? You know?
I'm gonna just pop it for, so it's not the lose any connection.
Okay, so let's go to
That's all right.
Let's not. Is that what we're gonna do? Yes. Okay, and then also we make sure that everybody can create here. Alright.
More than income investigation.
Hello, Mr. Cass, this is Lola again, calling you again. Are you ready for the conference? Okay, hold on a minute. Okay, you're on speaker. Can you say hello? can be heard.
Okay.
One more time for us.
William Cass calling in for the state.
Can everyone hear?
Yep.
All right, if you could, hold on a moment and we'll get things started shortly, okay?
Thank you.
Thank you, sir.
Remind you to turn off any cell phones, iPads, anything like that.
Okay, next, just straight to you.
And,
All rise. Court of Appeals Division 1 is now in session.
Thank you very much. Thank you. This is the time set for oral argument in Ramirez versus Superior Court Real Party and Interest State of Arizona. Let's begin with introductions of counsel. Ma'am?
Yes, I'm Lois Smith, I'm the attorney for the petitioner.
Thank you very much. Now, Ms. Smith, as you know, we have counsel for the real party in interest who's appearing with your consent, and we appreciate that by phone. So, sir, could you please identify yourself?
Yes, good afternoon. My name is William Katz. I'm a deputy county attorney for Yuma County. My last name is spelled K-A-T-Z.
Great, thank you very much. Let me go through a few preliminaries. And Mr. Katz, if for some reason you cannot hear the proceedings, let us know. Just please go ahead and speak up, would you please?
Yes, I appreciate that. Thank you. And I do appreciate being allowed to call in. I thank the court, and I also thank defense counsel.
Great, thank you very much. Well, each side has 20 minutes. We have, let me advise the parties that we have reviewed the papers that have been filed. We have discussed the case and conferenced it. We are recording these proceedings today, so when you speak, I think it will be pretty obvious to us in the courtroom who's speaking, but when you speak, you might wish to begin your remarks with identifying by name again. Let's go ahead then and begin with the petitioner.
Good afternoon, may it please the court, I am Kelly Smith, I'm attorney for the petitioner, and I'm requesting to try and reserve 5 minutes if I can.
Certainly.
Your Honor, today the petitioner requests that this court grant relief from the orders of Judge Bleich, the responding court, specifically finding that statute 133415E2, the specific subsection in question in this case, that the court find that that statute is unconstitutional and in violation of the separation of powers doctrine. As this court is well aware, the Supreme Court has the exclusive constitutional authority to make rules related to all procedural matters in any court. That clearly encompasses the rules of evidence, even though the legislature and the court branch can be, I guess the way to put it is that's not a bright line rule. Sometimes those things interweave, sometimes those things are blended. That's not the case in this case. In this case, what the legislature has done is clearly override evidence rules 401 through 404, and it's done that by stating shall in the statute, which is what, of course, the responding court relied on when it made its orders.
Let me ask you, excuse me,
No, go ahead.
a question. In light of the position that the state has taken in its answering brief that 403 is applicable, why doesn't that essentially moot that argument that you've just made?
I think because of what I just stated, the word shall. If the state had made that argument in the lower court and the statute had the word may in it, for instance, then I think that would be a valid argument or a valid way to resolve the matter.
But if you were to go back, if we were to decline jurisdiction and you were to go back and the state were to acknowledge that a Rule 403 analysis is appropriate, notwithstanding the language in the statute, is there anything that would prevent you from making the argument again in the trial court? You're not past some dead. There's not something that would.
Right. No, you're right. We could go back to Judge Bleish's courtroom. We could have the court do a 403, 404 analysis, whatever analysis under the rules of evidence that the court needs to make. And then I suppose, since I can't predict what Judge Bleish would do, it may be moot. But the fact is that Judge Bleish, in fact, did say that the statute says shall, and so she believes that she's precluded from doing the 403 analysis. We already know that that's the ruling. It's not a case where...
I'm just wondering if it puts it in a different posture if the other side comes in and says we agree that a 403 analysis is appropriate under these circumstances.
I think we still have the problem of that the lower court is, even if the state comes in and says that now, that doesn't mean that Judge Bleish will agree with that.
Well, that's fair, but the judge issued her rulings, at a time when the state wasn't saying that, correct? And this court, as I'm sure you know, is charged with avoiding separation of power issues when it can. Fair?
Fair.
And the state has now, candidly, in the first paragraph of its response to your petition, said, you know, a little bit differently than this, but upon further reflection, we believe 403 does apply. And I read your petition as largely taking exception to the court's failure to apply 403 for a portion of this. Now, she did exclude some other convictions that you're not challenging and has not been challenged by a petition before this court. But with respect to the prior paraphernalia convictions, the court declined to do a 403 analysis at a time when the state said no such analysis should be made. Is that fair?
Right.
We're in a different world now. Would you agree?
I would agree. I think what the court is essentially trying to say then is that maybe because of the state's conceding that it's premature until we know what Judge Fletch's ruling would be regarding whether she would do a 403 analysis.
Well, I think a lot of the force of your separation of powers challenge, particularly given that, as you point out, the dichotomy is not pure. There's some overlap. It's a little sloppy at times. Doesn't a lot of the force of your separation of powers argument go away if the trial court applies 403?
I think it does. The reason I would encourage the court to hear it at this point is because I think it's something that will reoccur consistently, and the word shall is there. I mean, that's the bottom line. I think the word shall is there, and it's a problem that should be resolved, and that Doty doesn't resolve because it wasn't raised.
Doty stops just shy. Now, and it talks about that in the footnotes, as I recall. But Doty is the only case that I'm aware of that's in the history of the statute that's a published appellate decision that's addressed it. Is that fair?
That's all I found as well. Yes.
Okay. I interrupted you, counsel. Please continue.
So I would submit to the court that if the court does want to find on that matter that it clearly is an unconstitutional statute. I mean, this isn't an area where we're discussing whether it's procedural or substantive. The state's not arguing that. I think it's clear that it is a procedural an impingement on a procedural rule.
Let me ask you, under that view, what's the remedy, though? Is that to say then 403 applies, or that the statute is unconstitutional?
I think it's fair to say that, coming in here, I anticipated that question. I think the only way that you can reconcile, which is of course what the court always wants to do. We don't want to find it unconstitutional unless you absolutely have to, right? We're supposed to try and work them out, and the only way to do that is essentially say, well, they didn't really mean shall. What they meant was may. Or they meant shall, conditioned on 401 through 404, conditioned on the other rules of evidence, all other things being considered, then you shall consider these things.
Well, and as you know, shall is a word that can have many meanings, at least in courts of law. And at times it can be construed as mandatory, and at times it can be viewed as discretionary. So the use of the word shall it begins the journey to answer the question. It's not the answer itself.
True, although I think more times than not, shall is construed as mandatory.
And I think the cases numerically would support that. But there's a substantial plurality or minority that go a different direction. And if in fact the state has conceded that 403 applies, isn't that all? Couldn't we avoid that sort of dicey, thorny issue by giving the Superior Court an opportunity to consider the evidence under 403?
Yes, I think if this court were to advise the court below, or mandate the court below, to consider the rules of evidence in conjunction with construing the statute, I do think that is a fair way to resolve it.
Let me ask you a practical question. If both parties, as they have here, have indicated that 403 applies, do you have reason to believe that the Superior Court wouldn't abide by that?
I'm sorry, is that question directed towards the state or Ms. Smith first?
Petitioner, thank you.
I don't believe so. I mean, I have to be honest. I think if the state had conceded that, I think Judge Fletch would have done a 403 analysis.
Thank you.
And even the court can see that later on she kind of did, even though
On unrelated
on
sort of
unrelated,
convictions, right?
kind of on her own, she had, and I know it's not all in the record, but the state's aware, she had sent an email saying, hey, I kind of want to clarify, and then we did it on the record the next time we went to court.
And I should say, I said unrelated, that's probably a poor term, different convictions. How about that?
So she didn't suggest that she had also considered 403 in in addressing the paraphernalia, the prior conviction for paraphernalia?
She didn't use the words 403, and I don't think that she actually did a 403 analysis. That would be my argument. She did use some words to the extent of, I think it might be too prejudicial, or I think it might be prejudicial.
Relating to the paraphernalia, or
No, to the
just to
other.
the drugs, right?
Yes, to the
Okay.
non-paraphernalia drugs.
Right.
The non-paraphernalia priors.
But I guess just going back kind of to the original question, there's presumably a remedy on appeal, and it's in a different posture if you've gone back and both parties have said it is subject to a 403 analysis, then it makes for a pretty good issue on appeal, presumably, if for some reason the court declined to follow the party's recommendation.
Yeah, I think if we went back to the Judge Bleich and she said, no, I'm still standing firm on shall, I think I would do another special action, I have to be honest. I think I would argue before her that it was unconstitutional, if she still believes shall, that it was a violation of separation of powers, we would be right back up here. If, however, she did the 403 analysis, if there was a 404B analysis or any other evidentiary rule analysis, and she did all of those analyses, and there wasn't any other issue, then I think it would be more of an appellate issue versus a special action issue. I think the reason that this is special actionable in this case is because this was the first time, to my knowledge, for instance, the statute had even been used in Yuma. So it had never even been used. The only case on it is where it was just a case from not this panel but this division last year, Doty. That's the only published case on it. And because of the posture of the state at the time of argument, that shall mean shall, we don't get to 403B, or we don't get to 403, that's why we believe that this was absolutely something that would occur again and again, because arguably now that it's been used once and you might be used again. So it's something that's going to reoccur and needs to be, and obviously the judge agreed, that's why she granted the stay. She thinks it needs to be resolved before we proceed to trial.
Assuming for the moment that we think that this issue should be addressed on special action, going back to the merits of your argument, when I was looking at this and thinking about, the separation of powers argument, what the statute reminded me of is that we have a number of other state statutes in other contexts, in which the legislature has said, okay, finder of fact, you must or you shall consider these factors in rendering a decision. And they have not presented separation of power problems. Now, maybe someone just hasn't thought to argue them. But in this case, not only did the legislature say, you shall consider these factors, but it left it very open. It didn't try and cabin them. It said, in addition to all other logically relevant factors. So in that context, when the legislature said, well, at a minimum, we want you to consider these, and then you consider anything else you think is logically relevant, I have a hard time saying that that level of discretion given to the finder of fact presents a separation of powers problem, in that it somehow interferes with the Supreme Court's rulemaking authority.
Well, if it's in the context of the other rules of evidence still apply, then I agree with the court. I think the argument is that, because then you can read them in harmony, or you can at least attempt, and a court can apply it, assuming there is a theoretical way that courts can apply them in harmony. It's not a problem. The problem here is, of course, the word shall. I mean, the word shall is essentially overriding the other rules. It's saying, what the court found in this case is, because it says shall, these prior convictions have to come in. It doesn't matter how prejudicial they are, and it doesn't matter what the reason the court is bringing them in for. Which, the state, which is particularly important in this case, because the position of the defendant and the petitioner in this case is that the state is simply bringing them in to show evidence that would otherwise be precluded under 404.
Was the Superior Court asked to, and I know that this issue was resolved for the second time right on the morning of trial, and so trial has not really begun. But did your client or your client ask for limiting instruction, and was that refused?
Yes, well, we asked for them to be sanitized in the alternative, and
Right.
that was refused. We also asked for a stipulation from the state, which was also refused. A stipulation that the fact that this was drug paraphernalia was not an issue.
But let me ask you a somewhat different question, though, because the statute, I think, makes prior convictions, and I'll use that term broadly just because it's not relevant to what we're talking about here, potentially relevant to paraphernalia charges, not for all charges. Was there a request that the jury be instructed they consider this evidence solely for that charge?
As opposed to possession of methamphetamine
Right.
charge, the other charge? No, there was not a request for
Okay.
that.
Just piggybacking a little bit on what Judge Norris was asking, when it says shall consider, if we said, for example, shall consider any statements a defendant has made, we wouldn't necessarily include that to mean you shall consider inadmissible hearsay. I mean, it shall consider, so you can kind of read it as subject to the rules of evidence, which would include presumably 403.
Right. I mean, of course, it would be nice if the legislature wrote things like that. It would make things a lot easier, but then we all wouldn't have jobs, right? Yeah, I mean, you would have to read it that way. I mean, you would have to interpret that's what they really meant, that they meant limited to the other. You know, it's just, at least the majority of cases, I would say, at least in quantity, and I think in large part, a large majority of them, shall is a shall, and I think that's why the judge ruled the way she did. But I agree with the court that if the court were to read it that way, that certainly that's not in violation of the separation of powers, because the court is essentially either inserting a clause in there, subject to the other rules of evidence, or kind of changing shall to may, which is also an implication that the other rules of evidence apply as well, because it's not mandatory then that the jury hear about these prior convictions if for some other reason they would be excluded under the rules of evidence. All is there. Thank you.
Thank you, Ms. Smith. Mr. Katz, sir?
Yes, hi. Yes, Your Honor. I'm sorry, excuse me,
Yes.
yes.
You may now go ahead with your argument, please.
Your Honor, may it please the court, I am listening to the previous set of questions advanced by the court and also the responses by defense counsel. I'm of the position that it is the state's position that given that we have acquiesced and acknowledged that a Rule 403 analysis is appropriate, I really think that at this point in the proceedings that it does move the issue with regard to this alleged separation of powers argument. So our first position that we'll be advancing here is, in our brief, first we take the position that this is not necessarily the proper subject or a proper subject for special action or relief. We do continue to assert that this defendant does have an equally plain, speedy, adequate remedy on appeal, and that this should be taken up under 13-4033 if a conviction is obtained. But looking at, I suppose, the merits that's being advanced by defense counsel, it is mooted at this point, and we do agree that the trial court, under its function under Rule 104A and Rule 104C, should be looking at a paraphernalia conviction or any drug conviction as a gatekeeper and doing a 403 analysis. Now, ultimately, we argue that under a 403 analysis, focusing on whether unfair prejudice is present, given that this is one of the criteria that a legislature has enumerated, simply because someone's been convicted of a paraphernalia or a drug conviction in and of itself is not sufficient alone to fail under a 403 test. But I really think the only issue that defense counsel is arguing is, should a 403 test be given? And yes, it should be given by the trial court. We agree. I reviewed the appellate brief written by, as I recall, I reviewed it, written by the state versus Doty, and it seemed either implicitly or explicitly to acknowledge that 403 was an issue. I think defense counsel herself pointed out that Doty has a footnote that deals with 403, and I really think 403 is something that should be done, and the trial court in this case, if this is remanded, would do a 403 analysis.
So you agree there's no impediment then to the court doing that? If we were to decline jurisdiction, there's no impediment to the trial court revisiting that ruling?
Yes, and I'm sorry, the phone cut out somewhat slightly. It was my understanding the court said that if a court declined jurisdiction, that the trial court could still do the 403 analysis.
Right, there's just no impediment to that at this point.
And that's the state's position. We think that the trial court should do a 403 analysis. We're interested in the trial court applying the rules of evidence to this issue and ultimately applying the Rule 403 analysis. We would be, of course, arguing that not only is the paraphernalia conviction admissible, but also the underlying drug offenses, which I mentioned in my third reply argument. I noted in defense counsel's reply brief that she's argued that the state has not properly filed a cross appeal. It's my understanding that we are litigating one order here. We are litigating the same issue. And essentially by raising this third reply argument that I have, that the court did not properly apply 3415A and that it automatically excluded the drug convictions, it's the state's contention that by raising this argument, that is not a cross appeal, since we are still looking at the same order of the same court trying to apply the same statute, 3415 E2. So we disagree with defense counsel on that. We are requesting the court that the court does accept jurisdiction, that the court does consider our third argument, that the trial court's interpretation of 3415 E2 is pertaining only to drug paraphernalia conviction is respectfully incorrect, that the language in it actually states any drug conviction. Essentially, I believe that a lot of the questions and answers that were provided earlier address the state's concerns. We do think that a 403 analysis should occur. We do think the trial court will conduct it. And aside from requesting that this court, if it does accept jurisdiction, essentially reverse the trial court's order with regard to the other 4 drug convictions, the state will incorporate by reference its brief and has no further argument, but I can't take any questions if the court was willing.
Mr. Katz, the panel does not have any additional questions for you. So with that, then, Ms. Smith, you have 4 minutes and 40 seconds for your reply.
Well, to address the last matter that the state brought up, I do think it's an impermissible cross-petition because even though there were some, I guess you can look at it like it was one order of the court, but really it's, I would argue, 2 separate orders of the court, even though they're on the same issue. And the state is asking for affirmative relief, which the court's order advised should be a special action if the real party in interest or respondent would be asking for such relief. So it would be our position that the court shouldn't address that matter. With regard to the original argument as well on separation of powers, I would also submit to the court that because it was argued shall at the lower court appeal, at the lower court, we never really got to 403 or 404 for that matter, which would also be a reason for the statute to be found unconstitutional, because we would argue that, I suppose the implication of 3415 is that these matters shall be considered by the court because they do in fact go to, I guess the argument would be, and again, I'm kind of making some theoretical arguments here, but motive, knowledge, intent, or absence of mistake or accident. I mean, that would be the implication. Otherwise, it is in direct conflict with Rule 404 as well, because 404 doesn't allow evidence of a person's past crimes or acts for the purpose of proving that he acted in conformity to this current crime. So even though that wasn't argued as strongly at the trial court, I would argue to the court that Judge Blake would have to make all of that analysis if we went back to the trial court, because if those analyses were not all made, then we'd be right back here again with the separation of powers argument. Is there any other questions from the court?
Thank you, Ms. Smith, and Mr. Katz, thank you very much, and we also would like to thank you both for being so cooperative with the telephonic hearing today for Mr. Katz. We're going to consider the matter further, and we'll issue an order in due course. Thank you very much.
actually, it's